I encourage active audience participation. I want it to be really interactive. And I think it's really exciting. We're dealing with three strands: tax, competition, and investment. We have one speaker, Godwill, who's not able to be here. But without further ado, we'll proceed with our three eminent presenters. Go ahead. First is Thomas Millett.
Set of slides, just this picture to explain to you that those are beautiful people. Yeah? NEMA is not a name, it's an abbreviation, National Environmental and Environmental Management Agency. Ladies and gentlemen, international investment law is evil. I'm not going to expound on it. I think after the latest, with the recent book by Dr. Banja, we should be all aware of that. The draft investment protocol, ACFT investment protocol, mitigates some of the most egregious flaws of the international investment law, but it doesn't change its paradigm. My people, my beautiful people. Why not? First, because it applies only to intra-African investment, leaving bilateral investment treaties with third parties largely untouched. There's Article 49, Sub-Article 4, which states that the provisions of the protocol, investment protocol, might be taken into account while negotiating BITs with third parties. Might be taken into account. Now, let us think about the history. We have a very progressive, we are very proud of it, Morocco-Nigeria BIT from 2016. Very progressive. And Morocco might have taken this BIT into account while negotiating the BIT with Japan from 2020. But it didn't. Morocco-Japan BIT from 2020 is precisely this type of BIT we do not like. Very broad definition of investment, any kind of asset, including contractual claims, fair and equitable treatment standards, prohibition of performance requirements, which kills us, explicit prohibition to take measures equivalent to expropriation. Everything is there. ISDS, we discussed it, is full glory without exhaustion of domestic remedies. Second, the dispute resolution mechanism has not been fully agreed upon. We know we discussed it yesterday. Most important is what I'm going to focus on is being addressed only in the context of investors suing the host state. And third, is also my important point, the institutional framework in the draft investment protocol is not robust enough. It's not robust enough to spearhead what I would call regional development-oriented investment governance. There's a committee on investment. We do not really know what it is supposed to do. It's not specified. Pan-African Trade Investment Agency, which is affiliated with the Secretariat. So, some reforms, commendable reforms, of the evil international investment law, but not a paradigm shift in the international investment law. I want to make 2 points in this regard. Why not a paradigm shift? But first I would like to discuss with you this case. This case is about export processing zone license granted to an operator of a lead smelting factory who happened to be a foreign investor. What is now a lead smelting factory? It's basically burning used car batteries in a furnace for over 2 hours and extracting lead from those batteries. So what you have to do, you have to basically manually disassemble a battery, a car battery, cart it using a hand cart or basically a wheelbarrow, and then put it into the furnace where it is going to burn. Yeah? Then you get something which is called unpurified lead. Then you take this unpurified lead, also with this hand cart, you store it, let it cool for some time, and you heat it up again, and then you get purified lead, which you can sell at high profits. And now this factory was set up in the Uhuru Owino village. It's informal settlement, low-income informal settlement in the city of Mombasa. The people protested against this factory. This is, you see my beautiful people protesting, and filed a case for damages against the operator in the Kenyan courts. Why did they protest? I will just read you from a court judgment, some testimonies of witnesses. Now, so first, what was happening inside the factory? I read you a quote from the judgment. EPZ Export Processing Zone, the license, those who granted the license were sued, and they are defending themselves in the following way. Our intervention was sought only in degazetting legal notice number 2027 of 1919, which exempted EPZ establishments, namely this factory, such factories, from the provisions of the occupational safety and health regulations. I read it again. Degazetting a legal notice which exempted EPZ establishment from provisions of occupational and safety and health regulations. Let's just savor it for a moment. So apparently, exemption of factories from safety regulations was degazetted, but how did it look like in practice? There's no reality. I'm quoting a testimony of Hamisi Mwamero, who is a casual worker. He was found to have 33% lead content in his blood. He asserted that he had never been tested while working at the factory, and some of his colleagues, called George and Carissa, had died mysteriously. The same witness about the battery melting process. He continued that the place where the non-purified lead was stored had such toxic fumes that would make people faint. The factory provided them with masks and gloves irregularly, which would get worn after a short while. That's inside the foreign investors' factory, outside of the factory. Again, a quote. The factory has been discharging liquid waste through a hole in their boundary wall into a trench that runs through Owino village and into the municipal drainage system. I read it again. The factory has been discharging liquid waste through a hole in their boundary wall into a trench that runs to Owino village. I am seeing my time is almost used, and I'm not even halfway through, so I have to a little bit squeeze it. So I may basically continue reading out you those testimonies about children who are dying, about people with high percentage of lead content in blood. You protect foreign investments. What is also important that EPZ approval, export processing zone license, was given without the environment impact assessment. That was then submitted 1 year and 2 months after the factory was already operating. The protesters were subjected to bureaucratic violence. Bureaucratic violence means they were complaining, letters were written to the operators, even the NEMA was threatening to close the factory, but actually nothing happened. Even parliamentary committees were dealing with that case. Now they filed a case in the court. They filed it in 2016 for compensation. The case was decided in 2019. Oh, highly publicized case. They won $12 million in compensation. Unfortunately, the Court of Appeal set this judgment aside in 2023. After 9 years, we are back to square one. Now, what does it have to do? 1 minute, 2 minutes, 1 minute, 30 seconds.
I gave you 2 earlier, so
thank you very much.
please round up within a minute.
Thank you.
Thank you.
Now, what does international investment do? My 2 points. Point number 1, fragmentation of international law. You said, oh, this is a human rights case, it's something different, go to domestic courts, use our imperfect regional human rights protection system. It has nothing to do with investment law. It detaches protection of investors from the protection against investors. And the protocol does not change anything in this regard. Say investment is good for development, investment gives you jobs. Yes, I give you a job, but you will die on this job. And international investment law does not do much about it, does not give you standing. And my second point, the paradigm change would be not just about overcoming the fragmentation, but also about overcoming the state-centric approach. The protocol to investments. The protocol is not blind towards indigenous communities, but it does not give them standing. The liability of investor is considered still to be a domestic affair. You may now sue the investor in home state. This is based on the Nigerian experience, this is what the protocol brings out. But liability of state party is international. So how is that? When the investor comes to another state, this is how cross-border international social relations with people in that state are being created. And the law must react to that. What the protocol still maintains is this idea of a state as fiduciary of individual interests. But this is not the case. My case, the case which I'm discussing here, shows that it doesn't, that the state is often not a fiduciary of the interest of people in Okuro or in a village. The investor colludes with the state. That's why people are saying Nema is killing us. So a paradigm shift in the international investment law will be also to overcome the idea.
Could you end up within a minute, please?
And done. Thank you very much.
Thank you.
Thank you, Thomas. Very passionate graphic, pointing out the intersections of human rights and bureaucratic violence, the intersection of human rights and international and investment law. So I'm sure we'll have more when it's time for audience participation. Thank you. The next speaker is Janet. Janet, go ahead, please, when you're ready. Thank you.
Thank you. Let me just... Okay, thank you.
Are you okay?
Yes, thank you. So, in the 10 minutes that I have, research that I've been working on for a while now on special economic zones. And the title, as you can see from the program, is Special Economic Zones and the AfCFTA, Between the Hopes for Trickle-Downs and Economic Distortions. And actually, Ralph's presentation was really good because it gives me an opportunity to give an introduction of what my research is about. And the general point of my paper is this: the tax incentives that are offered in the context of special economic zones are operators in African countries are illegal, arbitrary, and trade distortive. For this reason, they do not align with the regulatory goals of the AfCFTA. So that's the basic point. And to prove this, I first have to talk about special economic zones in a minute, and then conduct an legal analysis based on the rules that I use to make these legal points. So 3 things are important to understand, and I don't have the time to explain these very technical terms, but special economic zones have a very specific meaning, geographically delimited areas characterized by special regulatory rules. The investors basically get reliefs from fiscal and non-fiscal incentives. This paper focuses on the fiscal incentives, and those fiscal incentives are what we are calling the subsidies. All of you know about international trade law. I'm assuming you understand what subsidies mean. There's a very specific way to define a subsidy under the SCM agreement. The paper does this test and concludes that they are subsidies. Not only are they subsidies, they are contingent, in my argument, both in law and fact, on export performance and Article 3.1A of the SCM agreement. And then the other point is that even though certain countries enjoy the benefit of the exceptions under Article 27 and the annex to the SCM agreement, not all of these countries fit within the criteria. Which countries am I looking at? I'm looking at Kenya, Uganda, and Tanzania. The basic reason why these countries are important for the study is because there's an UNCTAD report that demonstrates that these countries, including also Egypt and Nigeria, account for the highest number of special economic zones in the continent. And so it made sense for me to focus on these countries. Kenya in particular accounts for, I think, 61 to 63 of special economic zones at the moment. And there's different types of special economic zones, but that's not the point of what I want to look at. So what are the characteristics of special economic zones? So in my research, I dig a little bit deeper into the types of special economic zones in these three countries. And the first thing that I uncovered is that we have a very different understanding of what we mean by special economic zones. So I'll give you an example, and there's a point to this, so just go with me. In Kenya, we have an Export Processing Zones Act, and we have a Special Economic Zones Act. And I took some time to go to the EPZ in Athi River, one of the oldest ones, the oldest one actually that we have, and had a bit of a chat with the head of research at the Department of Research. And he explained to me that, well, for purposes of the laws, we don't recognize EPZ and CES as the same thing. But from a definitional point of view, export processing zones are only a type of special economic zones, and this is also the case within the AfCFTA special economic zones regulations. And what this means is that the fiscal incentives that are offered for EPZ and for CES in Kenya are different. They are not the same. But when we cross over to Tanzania, the Special Economic Zones Act in Tanzania recognizes them as the same thing. So that's the first difference. The second difference is on account of the types of the rules that apply to the developers in these places. So Prof. Millet rightfully pointed out that once you're an operator or an enterprise or a developer in a special economic zone, and all these words have specific meanings, and once you're licensed, it automatically guarantees you all the benefits that come with being a developer in a special economic zone. For purposes of my paper, you don't have to pay taxes, so you don't have to pay VAT, you don't have to pay income tax, you don't have to pay stamp duty, etc. You basically get a free pass when you bring the inputs that are supposed to be used in the processing of the final product. So this is the first benefit that you get. If you check historically in countries like China and Ireland, and I talk about them a lot in the paper, part of the reason why the special economic zones in the context, for example, of China, for example, Shanghai and Shenzhen worked very well, is because this was a very specific model to the needs that they wanted to accomplish at the time. And the needs that they wanted to accomplish at the time was to build a domestic industry. And so it meant that there had to be a filtering mechanism as to who exactly gets to benefit from the incentives that come with being a developer in that country or in that zone. But that's not the case in Kenya. So when we moved from import substitution industrialization to export-oriented industrialization, what was realized quickly in the 90s is that we need to start attracting investment and exporting more, because this is how we are going to be able to develop our country. And essentially, if you want to get the benefits of the benefits that come with having a license in a special economic zone, all you have to do is to meet the minimum requirements of the capital that you need to invest within the area, and then you go through, you fill some forms, do a few checks, and you're given a license. That license guarantees you an automatic right to benefit from everything that comes with being a developer and enterprise in the special economic zone. Something else that is important that I uncovered is the rules in regards to how much you're supposed to export into the domestic market. So we have what we call deemed exports, which I won't go into in a lot of detail. Which I won't go into in a lot of detail. However, in Tanzania, they allow only up to 20% of exports within the region. So what we are within the EAC region. That is for purposes of special economic zones. In Kenya, only export processing zones are subjected to that rule. But for special economic zones, they get 100%. You can export up to 100%. Now let's move over to the AfCFTA and why this is important today. So we have the Protocol on Trading Goods, and Prof. Regis has written a lot on what the kinds of benefits that we're looking at the continental level for special economic zones in terms of the preferential trading preferences that come with goods originating from special economic zones. So I call this the double preference system. What does that mean? It means, first of all, the inputs get a benefit because they're not subjected to the taxes, so the products are cheaper. And then you get to benefit from the preferential trading system in the continent. So that's a double benefit. What does this mean for competition at the AfCFTA? It means that this is going to be trade distortive at that level, right? Because the products are competing at a different level. Not to mention the rules or how we rationalize special economic zones and incentives are not the same from one country to another. And this is just Kenya, Uganda, and Tanzania I looked at. And so the point of the paper is that we need to redesign how we rationalize tax incentives in the context of special economic zones if they are going to work for our benefit. There is a very specific way to design them, and I go into that in detail. And the second point is that we need to have a commonality, an institution that helps to rationalize these incentives. This one really that helps to rationalize these incentives. When the special economic zones regulations of the AfCFTA came out, and I remember talking to a few colleagues about this, I was optimistic about what these regulations were going to do. But because I thought that there's going to be some sort of minimum standard requirements, or there's going to be an institution that helps to bring together how we rationalize incentives at country level. But what these regulations did is allow every country sovereignty to determine the incentives and to regulate special economic zones as they deem fit. And my argument is that this trend is dangerous. And it's dangerous for what competition is going to look like at the AfCFTA level. So that's just the point of the paper. I thank you for listening to me. Prof, I kept time, and I look forward to interacting.
Thank you, Janet. Nothing like positive assurance on this side. I do appreciate it. I think it's very interesting that you brought up the fact of you highlighted Kenya's example and a little bit of analogy with Uganda and Tanzania. What I think is fantastic about your papers, it applies for Kenya for about 28 SEZs. What about the others, of which there are about 237 in the whole of African continent? So what can be drawn? You refer to, for example, Shenzhen, China, Ireland, and not just from other countries, but within the African continent, there's other states that can be learned that would be also very useful in this way to find a path of successful implementation. Thank you. The last but not the least is the speaker, and we have with us Martha. Go ahead, please. Thank you.
Good morning, everyone. I'm Martha. I've really enjoyed Janet's presentation. It's kind of, because mine now is an optimistic view of special economic zones. Hers was more of, quite not optimistic, but we'll see how it goes. So I'm Martha, affiliated with Mount Kenya University. I'm a student with a tech background, computer science, but I was interested in this meeting because I've been an advocate of the AfCFTA through my newsletter, Africa Not an Afterthought. So my paper is an analysis of the role that Kenyan special economic zones have played in the AfCFTA implementation, and is it a replicable model for intra-African trade growth? So as Janet has said, special economic zones, they are a designated area where the rules of business differ from the rest of the country. You have the tax incentives and all these other incentives. And my thought process in coming up with this paper, it was two things. Kenya has one of the highest number of special economic zones in Africa, so that's one. And two, according to the data, Kenya also has one of the highest rate of intra-African trade. So I thought, okay, are these two factors related? Is there a relationship there? And if there is a relationship, and the whole goal of the AfCFTA is to increase intra-African trade, then maybe we use SEZ, special economic zones, as a tool to help increase inter-African trade. So, in addition to those two factors, that Kenya has one of the highest number of special economic zones. This is data from UNCTAD and AEZO, although 61 is a bit of a distortion because I visited the special economic zone in Naivasha and they told me they've only gazetted 38. But even still at 38, it's still one of the highest. And then it also has one of the highest rates of inter-African trade. There are between January, that is last year, it hit the 200 billion mark for the first time in history. It's been increasing consistently. In addition to those two factors, we had Kenya was one of the first countries to ratify the AfCFTA. Kenya and Ghana, they were the first, and then chosen to participate under the Guided Trade Initiative. So Kenya has had time to play with the AfCFTA and see exactly what is going on. And I was wondering, is the fact that there was a framework of special economic zone a factor that helped Kenya really hasten the implementation of the AfCFTA? So after that, okay, I also did a bit of review. There was a paper that was done by UNCTAD on special economic zones and the African Continental Free Trade Agreement. I was just analyzing what this found and what I found in Kenya. So we get to here, and these are the two main questions that my research seeks to answer. So as we've said before, it stands out, highest level of inter-African trade and the extensive establishment of SEZ. How do these factors relate? And if there is a correlation between the two, and with the AfCFTA aim at boosting inter-African trade, how can special economic zones be effectively utilized to support the implementation of the AfCFTA? So as for the first questions, I found that the special economic zone and inter-African trade, there is a clear but indirect relationship. So what special economic zones do, they allow a country to increase the level of manufacture. And let me give you a bit of a background very quickly. So the first mention of special economic zones in Kenya was in Kenya Vision 2030 under President Kibaki. A lot didn't happen. Manufacturing was still contributing to Kenya's trade at 6.6%. And then we got to 2015, and the Special Economic Zones Act that introduced the Special Economic Zones Authority was introduced. At the time, we had manufacturing contributing to GDP still under 10%. After that, it has consistently increased that by 2022, manufacturing was contributing to Kenya's GDP at 11%. So my conclusion from that, and I did talk to some Special Economic Zones Authority official at Naivasha, and they did tell me that Special Economic Zones was a very key factor in creating this gradual increase of contribution of manufacturing to the Kenya's GDP, from all the way from 6.6%, then slowly to 8.4%, then to 11%. And as a result, I did come up with a conclusion that indeed there is a relationship between special economic zones and the increase in inter-African trade, indirect albeit as it is. Because once you increase the level of manufacturing, and Africa, when they trade with each other, there's a report that says when African countries trade with each other, they trade more in manufactured goods at a rate of 41.9%. So if you increase the level that manufacturing is contributing to the GDP of a country, automatically it increases the level of inter-African trade. So that answers this first question. So the second question then, how can SEZ be used to support the implementation of the AfCFTA? And I'll very quickly go through 5 of the factors that I found with the data analyzing structure of the SEZs in Kenya. So the first one is the structure of SEZs in Kenya. And we have the private and public model. The government is involved in setting up, for example, the Naivasha Special Economic Zone that I visited. The government is involved in everything. And then you have the private, who as an investor, as Janet has said, you can apply, and whatever, as long as you meet the minimum requirements, you'll be certified as a special economic zone. And what I found really interesting with this is, for example, you want to start to enter into something like maybe textiles, one of the goods that the AfCFTA is priorities industries. So if you have a land and you're dealing with that and you apply, as long as you meet the minimum requirements, you can be certified as a special economic zone and you will be free to start enjoying the incentives. And the advantages of this, the advantages of such a structure is that it gives, one of which is accessibility. It allows more people to access special economic zones, especially locally investors to access the special economic zones. The ability of a private investor to be able to apply and be certified as a special economic zone, that's the advantage. And then a big part of special economic zones in Kenya, a selling point that they keep on repeating, is that the AfCFTA is integrated. Like they tell you, you have access to the AfCFTA or the African market. Second, the incentives. So the incentive structure of special economic zones in Kenya, it cuts across both the public and the private, and it's special economic zones authority that is involved in making sure that it cuts across. And the main incentives that I want to highlight to start, Janet has mentioned we're exempted from VAT, from excise tax, from stamp duty, all those you are exempted. And then there's also the work permits. So if you're a foreign investor and you're coming to invest in a special economic zone, they'll facilitate 20% of the employees, I'm still on time, 20% of work permits. But what's so interesting about this is they're so strict. So if you're getting employees from outside the country, one of the first things that you have to certify is that you couldn't find that skill in the local market. Number two, you have to make sure that you employ a shadow employee who will shadow this expert, and within 2 years, you have to relinquish that role to the local shadow that you had employed. So, and then there's the one-stop shop, I think. It means all the people that you need, tax official, customs official, they're in the same region. So you have access to information. And the biggest advantage is that it lowers the entry barrier. So if you want to access, and we've already heard about all the issues that come with financing, especially in relation to the AfCFTA. So it lowers it lowers the barrier of entry, so that you don't need as much maybe finances to break into manufacturing, and then now you'll be able to take advantage of the AfCFTA. I need to keep saying, so the other three, I'll just quickly rush to them. We have the location, where special economic zones in Kenya are set up. It's close to the resources that can be added value, which is a very big key thing in the AfCFTA. And then we have the economic activities. Let me quickly show you a diagram. So these are the main economic activities that special economic zones in Kenya targeting. And when you look at the priority industries of the AfCFTA, they overlap. We have agro-processing, we have logistics, and we have automotive. So if those are the industries that are being focused in the special economic zones, and they are also the industries that the AfCFTA, their priority, the AfCFTA is targeting, then that overlap, it ensures that it is very possible to highly take advantage of the AfCFTA. And finally, the cost of energy. This was a report by the Kenya Association of Manufacturers. They were trying to say, no, this was in 2017, when the contribution to GDP had moved to 8.4% from 6.6 and then to 11 by 2022. And one of the main agenda was saying the biggest issue that makes it so hard to enter into manufacturing is the cost of energy. If it can be subsidized, then it creates competitiveness and levels the playing field. And in Kenya, in special economic zones, electricity is 10 kilowatt per hour, and in the Naivasha special economic zone, it is at 5 Kenya shillings, 5 Kenya shillings per kilowatt hour, sorry. And for the others, 10 Kenya shillings per kilowatt hour. That is such an affordable cost of energy when you consider for the rest of the country, it's over 20 Kenya shillings. So these are the main factors that I saw that are very, very, can be used to help those who are investing in special economic zones to take advantage of the AfCFTA. And I think I'll end there so that I don't take much time.
Thank you, Martha. We come to a close in terms of panel presentations. I think this panel benefits with this hallmark distinction of having all the three speakers from Kenya, but it is AfCFTA that we're talking about, but we've had the benefit, added benefit of seeing insights from each of them. And it's the lessons, have been highlighted, for example, by Janet in a filtering mechanism from all to selected incentives. The other one is from Thomas in terms of investment law, the intersection of human rights and investment law, and from Martha is Kenya the poster child because of its number of SEZs that it has, and what lessons can be learned for the other SEZs in the rest of the other African states. I'm really interested, and I want to encourage you, the audience, to actively participate in contributing to your insights or whatever you can share, so that it can be a session where there can be lots of learning within the panel session and offline as well. Go ahead. Can I just check in terms of who would like to speak up, please?
I just have a question for Professor Thomas Village. I was interested in the presentation, and I agree with much of what you said, but can you tell us what would you do differently within the framework of international investment law? Or do you think that it's broken beyond repair?
I've been looking at the human rights provisions in the AfCFTA for a while now. That is a reset that's still on my table. And I find your presentation very engaging, enlightening, and thought-provoking. I want to ask you, have you looked at the provisions on labor and also on local communities? So, and how would you tie that in or measure that in the light of this case study that you have just considered? And I would love to engage further after this. Thank you.
Thank you.
For the two great ladies, Martha and Janet, we have the special and the EPZ. Currently, they are being merged to one entity in the country. And the major purpose of it was for export market. In your study, has it been able to achieve the purpose it was stated to? For example, we had the AGOA and the other purpose. Has it been able to achieve that?
So could you speak a bit louder, please? So,
the purpose of our EPZ and especially economic zone was more so for the export market. Have we been able to achieve the purpose from your study? So that we can be able to talk about that kind of trade agreement when you can start trading in it, so that we can live in the past. Thank you.
thank you. Regis?
Measures themselves. As you both know, NGZs, these are incentives which are provided to companies. They can be foreign investors or even domestic investors. So the challenge now lies in the fact that the goods that are manufactured in these zones can end up in the custom territory of the country or the custom territory of the economic communities to which the country belongs to. And now with the AfCFTA, that means there is a goods originating in an SEZ, or let's say Kenyan SEZ, which now competes with the good custom treaty of the economic communities to which the country belongs to. And now with the AfCFTA, that means there is a goods originating in an SEZ, or let's say Kenyan SEZ, which now competes with the goods coming from, let's say, another AfCFTA state party, which is not part of an SEZ. So that's where the challenge lies. And I hope that the AfCFTA rules of origin will clarify some of these questions. And the problem will be complicated now based on the fact that there are specific products such as automotive or sectors, like automotive sectors, or in the case of apparel and clothing. So some of these questions will be really important in the design of the AfCFTA rules of origin. So I would simply want to encourage you guys to look at specific products in your analysis, especially because, again, the reason why SEC are in place is because they want to encourage industrial development. And of course, the rationale behind leaving this as a side note, not a side note, it's something that's really important to African countries. This is why they didn't even realize, they didn't decide to kind of regulate SEC at the moment. So they said they will convene at a later stage to actually find rules on this specific question, because again, they're very important for, and industrial policy is something which African countries are actually trying to put in place. So we should really think about the reasons why this is being excluded for now, and look at the product which probably might be the reason why they are making it a project for the future.
More so for Thomas, a comment. I really appreciated your presentation because it resonated so much with corporate corruption in America. And how, how the country colludes with corporations in order to get sustainable income. But I have a question for Janet and Martha. Either one of you probably could respond to this. Should there be a uniform definition of SEC laws if each country has a unique need to generate economic growth? And is it more prosperous to individual countries to have a bifurcated system of trade by continuing to have SECs, or who actually benefits from the distinctions of its existence? Meaning, what I'm asking is, right, different companies apply the rules apply differently for SECs than they do under the AFCFTA, and is that bifurcated system more beneficial to the country or beneficial to the actual person who exempts?
Thank you. Can we have, James, please, and I think there's someone else near you. Thank you.
Yeah, so thanks for a great panel. I think my comments to Janet. So, two very quick things, Janet. One, it seems perhaps we need to revisit this idea that these are incentives. These are costs to the African governments. And I think we need to interrogate the question about characterizing them as incentives. And I know we had this chat yesterday about the availability of data. I think just accepting the idea of incentives is sort of the path leading us to all these problems that you and especially Thomas were pointing out. The second one is, I'm also a little suspicious of using the SEM, the Subsidies and Countervailing Measures Agreement, as a way of measuring what may or may not be happening. The US likes to attack India, for example, and suing India in the WTO. But if you actually think very carefully about this, the design of the SEM was meant to protect the major, huge subsidies in the West, and perhaps make it possible to target countries that are trying to make a difference. So I know my two suggestions are contradictory, but if you think about, for example, the very major trouble the developing countries had to conclude the fisheries subsidies agreement, because obviously the big countries did not want to reduce subsidies for fisheries. I think the subsidies there are humongous, they are major. And then the kind of incentives you're talking about here are minuscule relative to the huge subsidies. And we're not even talking about agriculture, for example. So I think that we need to own the narrative and not just take for granted the way that the debate has been framed. Because the debate has been framed in a very uneven field. So anyway, I just thought I would put out those thoughts for you to ponder, not that I have the answers myself.
Thank you, James. I think someone, thank you.
Thank you so much. My question is to Janet. In response to Martha's presentation. When you started, I was in agreement with you, but then when Martha started presenting, my thoughts kind of changed. Because I'm thinking, truly, AfCFTA is not the answer to everything, because the AU's agenda is to, spark, accelerate, promote inter-African trade. So, very quick question. Do you think both the EPZ and the SEZ with the difference in application and with all these contradictories, yeah? Is it working towards that agenda? And do you think this agenda is one of your priorities into African trade?
Okay,
I'd like to address a question to Professor Thomas. International investment law has been suffering harsh criticism. And this morning, I'm sorry, it has suffered more. For a good reason. We need responsible investment for the sustainable development of our countries. And the protocol envisaged a Pan-African Trade and Investment Agency. And my question is this, Professor Thomas, don't you think that this future institution can help member states devise more balanced or even human rights friendly investment contracts and treaties with non-African economic partners? This is my question. Thank you.
Comments, very useful. I'll just start with the first one. And yes, so the merger was very interesting. The merger between the EPZ authority and the SES authority in Kenya, it came after I started my research. So I was talking to Prof about this, and wow, this is going to be an interesting ride. So what the government realized is that there is an institutional challenge because you have the EPZ authority and you have the SES authority. Remember I said that the SES Act has a different regulatory regime for special economic zones compared to the EPZ. So what they want to do is that they want both of these authorities with the different legislations to operate as one institution, which is the Special Economic Zones Authority. So right now, what the declaration did by the president was to say, by the executive, was to say, look, all licenses, everything is going to be happening through the SES authority, and that is still in progress. And I've been doing a lot of work to try and see how exactly this transition is going to work, but that's essentially the point. And then you asked after that, what does that mean even with AGOA, etc. I spoke to Prof. Gadi yesterday. It was very interesting because I went to the AGOA website and looked at some of the data on Kenya's exports from special economic zones. And textiles account for, I think, second or third. Kenya accounts for second or third exports to the US of textiles. When you go to Athi River EPZ in Athi River, a lot of what they do is textiles. So what are we saying? We are saying that even though these APZs are getting some benefits, it looks like, at least preliminarily, these exports are not going into the country or the region or the continent. They are going to the US, at least for AGOA. Which is why it's interesting now. It's going to be even more crucial for me to interrogate exactly what exports are going into the continent, because that's important. But you see, the idea of the argument is, look, if we're talking about promoting intra-African trade, intra-African investment, it means we want to trade more with each other. So this is something we have to think about, even though it seems like preliminarily the current impact is not really being felt. But let me pin that, because there is a lot more to be said there. I have 1 more minute, so I'll just quickly rush through the other one. Let's talk about the types of investors, and this is going to cut across the next questions. What types of investors do we have in this SES and this EPZ? In Athi River, we have many domestic investors, fine. But when you go to Tatu City, there are Rendezvous, the urban developer, is privately owned. You will find many foreign companies, big companies, Heineken, etc., CCI. You'll find all of them there, and they are getting the benefits of being a developer or an operator or an enterprise that is licensed by the SES authority. What does this mean? Going back to Prof's point, who exactly is the beneficiary of these incentives? And as Prof. Gadi rightfully said, are they incentives or are they costs? And as I go even into your comments, Prof. Gadi, thank you very much for those comments. I know we talked a lot about the data. And the SCM agreement, it's interesting because you see how we think about subsidies is, is it a financial contribution, etc., benefit 3.1827, like that. But when you read the AfCFTA, it makes certain references to WTO agreements, which makes it increasingly confusing for me to understand the place of the SCM agreement in understanding what is a subsidy, or what are we saying about the place of the SCM agreement in the context of the AfCFTA, which is something I think that warrants a lot more conversation. But I am very grateful for all those comments, and there's a lot more to be said about the questions that came up, but I'm just going to give my co-panelists an opportunity to speak.
Thank you. So we had the questions and issues raised by the floor. You know, for example, Bakita raised human rights and labor, James with the points about debate, how you frame it, and at the same time we have Regis giving his comments in terms of analysis, and then the rules of origin can be better enhanced or elucidated. And I would like to, and then I think Faith mentioned about AfCTA is not the answer to everything. So if maybe each of you, the remaining, can put in your views as to what was raised and how you can incorporate that, or what you think of it, to better your essays and your presentations, that'd be great. Thank you.
Thank you. I think I'll address that question of the goods and the origin. Thank you so much for the comments. I'll dig into them. But also in a conversation with one of the Special Economic Zones Authority official, he told me that Kenya is taking the charge in leading on how to negotiate how special economic zones will be treated in the East African community. It is not yet done, but they told me they'll be done by the end of 2024. So I don't exactly know what they'll come up with, but I know they're having that conversation. And they did say that whatever they agree, they will forward that to the AfCFTA Secretariat. So that was in regards to that. And then Faith asked about whether there should be a uniform definition. I think also that is a very main key part of my paper, in that I'm trying to see if we can come up with a workable model that can work across Africa, so that we have one definition. And if we do end up coming with a list of regulations on how to treat goods from the special economic zones, and then we have a model that works across the continent, then I think all the countries get to benefit from that. Thank you.
Thank you.
Thank you very much. I would like to start with EPZs, although that was not a question directed to me, but I have just retrieved my electricity bill. And my electricity bill is for June 9,688 Kenyan shillings, which is around $70. You know, $70, I would like to pay $40 and not $70. Professor Gatti said that the incentives are cost for the government, but it's actually, I think, even worse. Yeah? It's me who pays for the incentives, so-called incentives in the special economic zones. The main incentive in Naivasha was subsidized electricity prices. Just to inform you, Kenya has the highest electricity prices on the African continent. Now, this model is being replicated in Dongo Kundu, special economic zone in Mombasa. When we look at the structure of investment there, 131 million, the highest share of investment of money was invested by 5 big companies. So 5 companies that are capable of investing $131 million. I mean, those are big players, and they get subsidized energy prices, which I pay for. This is wrong. I am a poor guy, and they are rich. And also, for, I don't know, 15 years in Kenya, apparently, special economic zones and export processing zones were exempted from occupational safety regulations, yeah, which is absolutely scandalous. So the point is, you see, the benefits of special economic zones are quite remote, yeah? Those are, as Janet put it, trickle downs. Yeah, we will have them sometime. You know, the volumes of intra-African trade will increase, the exports will increase, and then we will at some point walk on the sunny avenue towards a bright future. Yeah, but the costs are immediate, tangible. Now they hit us hard. The tax incentives, the government has to make up for it. Yeah, and the government of Kenya comes up with vehicle circulation tax, atrocious. Okay, my take on special economic zones. Now, to my questions, what would I do better? You see, I am engaging here to cite the classics in critique as wellness. I'm criticizing. What, however, my vision would be, and just to link it up with your question, I am not, of course, the protocol investment does something, yeah? It sets out the investors' regulation, the obligations for investors. It even comes up with a duty to report on how local communities are taken care of, yeah? It says that, it's a chapter is called Develop the Sustainable Development Related Issues, yeah? So what I meant is that it of course mitigates some of the evils, yeah, and some of the flaws of the international investment law, but it does not change the paradigm. That's my point. Changing a paradigm would be a development-oriented, holistic governance framework for sustainable investment in Africa, yeah, which would not just come up with some reporting duties, yeah, for investors, but which would recognize the agency of the local communities, the agency of people who work in those factories. Yeah? And if you look at the dispute settlement provisions in the investment protocol, it is only about the investor suing the whole state. There's nothing more. The local communities, those who suffer from, there's a nice word, negative externalities of investment, yeah? They have no standing. So this is what I mean, that there is no paradigm change. Yes, institutional setup. So there is a committee on investment, and the protocol does not even say what this committee of investment is supposed to do yet. My hopes are not, my expectations are not very high. The Pan-African Investment Agency is about more, the way I understand it, facilitating the investors, so to make it happen for the investor, to make investment happen. But of course, will all depend on the resources and the capacities of those institutions. Frankly speaking, given the state of regional integration as it is now, given what is, for example, happening to EAC Secretary. See? The Secretary General of the East African Community, we would want that it would be a powerful institution that stands for the community interest, yeah? That can speak on the same level with Museveni, with Kagame. Yeah? But this is a person who was treated by the President of Kenya as an assistant. Yeah? He was dismissed from the position of the Secretary General and appointed ambassador to Russia. So if we treat regional institutions like that, yeah, I'm not very optimistic. Thank you.
Thank you very much, Thomas. I wish to, the 1 hour session is coming to a close, and I've been advised about it. So I wish to thank to the presenters, Thomas, Martha, Janet, for excellent papers and for keeping good time, and to the audience for the active interaction and the engagement. And I hereby call the panel to a close, but before calling it to a close, I request if you can give a round of applause to the presenters.